There's a knock, not the delivery driver's quick double tap. 3 slow, heavy knocks, spaced apart, the kind that are meant to be heard through a closed door. You look through the glass, and there is a man in a stab vest with a body camera clipped to his chest and a folder under his arm. He has already taken a step back from the door, which makes him look patient and makes the space in front of your door feel like it belongs to him. Then he says the 3 words, "Everything turns on. Open the door." Here is what almost nobody understands about the next 90 seconds. Whether that man ends up inside your home today has very little to do with how much you owe. Your ability to pay does not come into it. Neither does whether he has the right address. What decides it is whether that door opens, not whether he forces it, whether you open it. That is written into an act of parliament and a set of regulations. And by the end of this, you will know exactly which words to say through a closed door. Why the law puts him under an obligation the moment you say them. The 4 situations where he can come in anyway, and the one thing you must never do, because it carries a prison sentence, before anything else. This is England and Wales. Only England and Wales. Scotland runs an entirely separate system with sheriff officers under its own legislation, and Northern Ireland is different again. If you are in Scotland or Northern Ireland, none of what follows describes your position, and I would rather you found that out now than 18 minutes from now. This is legal education, not legal advice, and I am not a solicitor. Let me also be blunt about the company this subject keeps. Search this topic and you will find a lot of people telling you that these agents have no real power, that there are magic words that make a debt disappear, that you can simply refuse to engage and it all goes away. That is nonsense, and the people repeating it are getting other people's cars taken. Everything that follows comes from the statute and the regulations, and I will name them as I go so you can check every word of it yourself. So, start with the man on the doorstep and the correct name for him, because the name tells you what he is. The word bailiff is a leftover. Since the current system began in 2014, the legal term has been enforcement agent, and the framework for what he can do is Schedule 12 of the Tribunals, Courts and Enforcement Act 2007. The warrant or the liability order behind the visit matters too, and so do the regulations underneath it. But Schedule 12 is where the powers themselves live, and the first one is smaller than you would expect. Paragraph 14 says, and this is the actual wording, an enforcement agent may enter relevant premises to search for and take control of goods. That is the power in full. He may enter. Notice what that sentence does not contain. There is no mention of force. No mention of breaking in. No mention of what happens if you say no. Parliament gave him permission to come in. That paragraph, on its own, gives him no way to force you to let him in. Force sits in a completely separate paragraph, paragraph 17, and it is written as a list. It says that where paragraph 18, 18A, 19, or 19A applies, an enforcement agent may, if necessary, use reasonable force. 4 numbered doorways, and we will go through all 4 because you need to know whether you are standing behind one. If you are not, the power to force entry was never granted in the first place. There is a second lock on this, in the regulations rather than the Act. Regulation 20 of the Taking Control of Goods. Regulations 2013 tells him how he is allowed to come in, and the word it uses is only. He may enter only by any door or any usual means by which entry is gained to the premises. Read that carefully because it cuts in 2 directions at once. It rules out the things people are most afraid of. Climbing in through a window you left on the latch, forcing a lock, shouldering past you in the doorway. The government's own guidance compresses all of it into one line. Bailiffs cannot enter your home through anything except the door, and cannot enter by force, for example, by pushing past you. But usual means is wider than your front door, and this is the part that catches people out. If the side door is how people normally come into your house, and it happens to be standing open because the dog is out, walking through it is not force. He has to come in the way anybody comes in, which in practice means through something you have left open, or something you open for him. So before you do anything else, know what is open at the back of your house. No open door, no lawful way in today. Before we get to the sentence, check one thing, because there is a decent chance this visit should not be happening yet. On the 1st of May 2026, the rules changed. A new set of regulations came into force, made at the Ministry of Justice on the 24th of March, under the title Taking Control of Goods Miscellaneous Amendments. It did three things that matter to the person standing at that door. The first, before an enforcement agent can take control of your goods, he has to give you notice of enforcement in writing unless a court has specifically ordered a shorter period. That notice used to be 7 clear days. As of the 1st of May, it is 14 clear days. The amendment itself is 1 line long. Where the regulation said 7 clear days, substitute 14 clear days. The second is bigger, and hardly anyone has caught up with it. There is a brand new provision, Regulation 6, 1A. If a debt advice provider submits a request on your behalf before your notice period runs out, that minimum must be extended to 28 clear days. Not maybe, must be. That is double the time. But the conditions are strict and easy to miss. You cannot trigger it yourself by ringing up and asking nicely. It has to come from a debt advice provider on your behalf, and it has to land before your current period expires. So ring them today and ask them to confirm back to you that the request has actually gone in. And the third, the notice itself now has to tell you both of those things, that free debt advice exists and that the extension exists. So if the paperwork in your hand says 7 days and says nothing at all about free advice, you are holding a notice on the old form. Be careful what you conclude from that, though, because this is where people talk themselves into trouble. Old paperwork does not automatically make the enforcement invalid. The regulations came with a saving provision, and action already underway before the 1st of May carries on under the old rules. What an old form does mean is that the dates are worth having someone look at. One more detail so you do not misread your own letter. Clear days are the whole days in between, which means you do not count the day the notice was given, and you do not count the day of the visit. And Sundays, bank holidays, Good Friday, and Christmas Day do not count at all. So while he is standing out there, the question in your head is not, can he come in? It is, when was my notice dated? And has 14 clear days actually passed? Now, what do you actually say? I want to build it with you rather than just hand it over, because a sentence you understand is one you can still say when your heart is going. The mechanism you are about to use is paragraph 26 of Schedule 12, and it is the most useful paragraph in the entire schedule for someone standing behind a door. It says the enforcement agent must, on request, show the debtor evidence of his identity and his authority to enter the premises. Read the two halves of that. Must, on request. It is an obligation on him, and it is switched on by you. Until you ask, he is under no duty to prove anything. The moment you ask, he is. And then subparagraph 2, which is the part that makes this work through a closed door. The request may be made before the enforcement agent enters the premises, or while he is there, before he enters. Parliament wrote down that you can demand his credentials from the wrong side of a door he has not come through. Asking is not obstruction. It is the procedure the statute lays out. The government guidance turns that into something physical, and it is the most practical line on the whole page. You can ask for proof of a bailiff's identity and authorization, even if they have visited before. For example, ask them to put it through the letterbox or show it at the window. Through the letterbox. That is the official suggestion on the official page, and the same guidance lists what you are entitled to see. Proof of identity such as a badge, ID card, or enforcement agent certificate, which company he is from, a telephone contact number, and a detailed breakdown of the amount owed. That last one does more work than the rest combined. The number he says through the door is not the debt. It is the debt plus his fees, and the fees are fixed by law, so a breakdown is checkable. If he will not itemize it in writing, you have learnt something important about the visit. So here's the sentence. Say it calmly through the closed door, and do not open it to say it. Certificate is the word to use because that is the document a certificated enforcement agent has to hold. I'm not opening the door, but I'm not ignoring this. Hold your ID and your certificate up to the window, and post the full breakdown of what you say I owe through the letterbox. I'll respond in writing today. Now, why those exact words and why in that order? I'm not opening the door. Plain refusal, no apology, no explanation. You do not owe him a reason, and reasons invite negotiation. The government's own words are that you usually do not have to open your door to a bailiff or let them in. But I'm not ignoring this. This clause is the one people leave out, and it is the one that protects you. It separates you completely from the crowd who think refusing to engage makes a debt evaporate. Refusing to engage is how the fees climb and how your car disappears. You are refusing entry, not the debt. Hold your ID and your certificate up to the window and post the full breakdown through the letterbox. Two separate instructions because they are two different kinds of object. And this is where a lot of well-meaning advice gets it wrong. He is not going to feed his identity card and his enforcement agent certificate through your door and leave them lying on your mat, and you should not ask him to. Those are things he has to keep. The government's guidance actually gives you both mechanisms in the same breath. Ask them to put it through the letterbox or show it at the window. So use the window for what he has to keep hold of, and the letterbox for the paper you need to keep. And I'll respond in writing today. A deadline you have set, on a record you control. Say today and then actually do it. Now the part that explains why the door matters so much. Suppose the door opens. He is polite and he does not take anything. Instead, he sits at your kitchen table and produces a form called a controlled goods agreement. You sign it because signing feels like the cooperative thing to do and because he says it stops him taking your things today. Read what you have just signed. Schedule 12 describes it. You keep possession of the goods. You acknowledge that he has taken control of them. And you agree not to remove or dispose of them. That has not protected your possessions. It has converted them into his security while leaving them in your house. And now go back to paragraph 17, into the fourth of those four doorways, paragraph 19A. It applies where he has taken control of goods by entering into a controlled goods agreement with you, and you then fail to keep to the payment terms, and he has given you notice that he intends to come back. Then he may use reasonable force. Look at what that does to your position. Before you open the door, he had no lawful way to force it. Afterwards, he has one. Two conditions have to be met first, and both of them matter. So nobody should tell you it happens automatically. An actual breach of what you agreed. And notice that he intends to come back. But by signing that form, you did not buy yourself protection. You gave him a way in that he did not have while he was standing on your step. That is why the door is not about being rude to a man doing his job. It is the difference between a visit and a right of return. Now let me be straight with you about the four doorways, because pretending they do not exist is exactly the pseudo-legal rubbish I promised you I would not do. There are situations where he can force entry, and you need to know whether you are in one. Paragraph 18. A warrant of control from the magistrate's court for a sum adjudged to be paid by a conviction. In everyday terms, that is the criminal courts, an unpaid fine, and also things ordered alongside it like prosecution costs, compensation, or the victim surcharge. Note the word conviction because it is doing the work. Council tax arrears are not a conviction, even though a magistrate was involved in granting the liability order. Paragraph 18. Asa. He reasonably believes you carry on a trade or business at the premises, and he is enforcing a high court or county court judgment, and the judgment is not for a traffic debt. Read that one twice if you work from home, because the test is not whether the building is a shop. The test is whether he reasonably believes you carry on a trade or business there, and nothing in the paragraph says the premises cannot also be where you live. If you are self-employed and you run it from the spare room, do not assume this doorway is shut to you. That is a question to put to a debt advisor, not one to guess at. Paragraph 19. Re-entry where he already took control of goods, and again the trade or business test has to be met, either for a high court or county court judgment, or for unpaid tax under the Finance Act 2008, which is His Majesty's Revenue and Customs. And paragraph 19A, which we just did. The broken controlled goods agreement, the government summarizes the practical effect this way. Bailiffs are allowed to force their way into your home to collect unpaid criminal fines, income tax, or stamp duty, but only as a last resort. Ordinary council tax arrears, a parking penalty, a county court judgment against a private household on a first visit are not in that list. One more thing about force, and it is short. Paragraph 24 says, a power to use force does not include power to use force against persons. Even where he can break a lock, he cannot lay hands on you. Now, the honest limits, because a video that only tells you the good half is not worth watching. The first one is the important one. A closed door protects the inside of your house. It does not protect your car. If the vehicle is on the drive or in the road outside, there is no door involved and nothing to refuse. The government guidance says it plainly. If you do not let a bailiff in or agree to pay, they could take things from outside your home, for example, your car. I want to be careful with what I say next, because this is the point where bad advice does real damage. Do not go outside and move the car while he is standing there. 2 reasons, and both are serious. You would be walking into a confrontation you have just spent 10 minutes avoiding with a body camera running. And once he has taken control of a vehicle, moving it, hiding it, or selling it is intentional interference with controlled goods, which is a criminal offense under paragraph 68. From behind a door, you cannot always tell whether he has already clamped it or listed it. So the car is not a thing to solve in the next 90 seconds. It is the reason you pick up the phone the same day. Whether it can be taken at all turns on things an advisor can check quickly, and you probably cannot. Whether it is yours in law, whether it is on finance, whether somebody else owns it, whether you need it for work in a way the regulations protect. Keeping the door shut protects what is inside the house. It buys you nothing for what is parked outside it, and the answer to that is engaging quickly, not hiding it. Second, timing. Regulation 13 says he may not take control of goods before 6 in the morning or after 9 at night. Regulation 22 applies the same window to entering and staying, but Regulation 12 says he may do it on any day of the week. And people get this backwards constantly. Sunday is not protected. Bank holidays are not protected. The restriction is the hour, not the day. Third, who is in the house? Regulation 10 says he may not take control of goods where the debtor is a child, or where a child or a vulnerable person is the only person present. Regulation 23 says in those circumstances he may not enter or remain at all. The government puts the age at under 16. If you are a vulnerable person, you may also be able to get extra time and debt advice, and that is worth saying to the debt charity, not shouting through the door. Fourth, what he cannot take, even if he is inside. Regulation 4 lists exempt goods, items and equipment necessary for your own use in your employment, trade, profession, study, or education, up to a total of 1,350 pounds. And separately, the clothing, bedding, furniture, and household equipment reasonably required for the basic domestic needs of you and everyone in your household. The regulation spells out examples: a cooker or a microwave, a fridge, a washing machine, a dining table, and enough chairs for the household, beds and bedding for everyone, one telephone, and anything reasonably needed for medical care or for safety and security in the home. One correction, because this gets misquoted everywhere. That figure of 1,350 pounds caps the work tools only. The basic household items have no cash ceiling on them at all. They are protected by whether they are reasonably required. Now the fees, because this is why the doorstep visit is the expensive moment. Fees are fixed by regulations, and the same instrument that moved the notice period put them up. For ordinary enforcement, the sort that is not a high court writ, the compliance stage, which is the letter, is 79 pounds. It was 75. The enforcement stage, which is triggered by him coming to your door, is 247 pounds. It was 235. The sale stage is 116 pounds, up from 110. Those figures had not moved since 2014. 12 years. The only amendment in between dealt with VAT and left the numbers alone. So if you are comparing your letter against advice you found online, and the advice quotes 75 and 235, that advice is from before May. There is also a new protection worth knowing, though it is narrower than it first looks. For high court writs only, if no contact is made at the first attendance, the agent cannot escalate to the second enforcement stage until you have been given another chance to pay or to come to an arrangement. On the high court table, that second stage is 520 pounds, so it is a real protection. But it is high court writs only. It does not apply to your council tax. Now, the line you must not cross, because crossing it turns a debt problem into a criminal record. Paragraph 68 of Schedule 12 creates an offense. A person is guilty of an offense if he intentionally obstructs a person lawfully acting as an enforcement agent, or intentionally interferes with controlled goods without lawful excuse. The maximum on summary conviction is 51 weeks imprisonment, or a fine at level 4, or both. Maximums are not what ordinarily happens, and I am not telling you this to frighten you. I am telling you because it is the one place where a bad 10 seconds costs more than the debt. Notice the word that appears in both halves of that offense. Intentionally. This is about what you deliberately do, not about being unhelpful. So be precise about which side of that line each of these sits on. Keeping your door shut is passive. Asking for his identification is a request the statute expressly allows you to make before he enters. Saying you will respond in writing is engagement. None of those is a deliberate obstruction of anything. Putting your hands on him, slamming a door onto a hand or a foot, moving, hiding, or selling anything he has already taken control of, snatching paperwork out of his hand. That is a different category altogether, and it is not worth a single pound of what you owe. Say the sentence, then stop talking. You do not have to win the conversation. You only have to not open the door. So here's the whole thing. Back at the doorstep, in order. You do not open the door, and you check that nothing else into the house is standing open. You say the sentence once calmly. If he keeps talking, you say the same sentence again in the same tone, and then you stop answering. You do not go outside, and you do not touch the car. When he is gone, you pick up whatever came through the letterbox, and you find your notice of enforcement, and you check its date against 14 clear days. And then, the same day, while it is all still fresh, you ring a free debt advisor. That call is the part that actually changes your position for 3 reasons. They can ask for your notice period to go out to 28 days, and they have to ask before the current one runs out. They will know in a couple of minutes whether the figure quoted at your door is the right one. And they can tell you where you stand on the vehicle, which is the thing the closed door never protected. In England and Wales, national debt line is free on 0808, 808 4000. Step change is the other one, also free. Neither of them will judge you. And whatever else you do, do not pay for debt advice and do not pay a company that promises to make the debt disappear. Be clear about what a shut door has and has not done for you. It has stopped him getting inside today, and it has kept you out of a controlled goods agreement you did not understand. It has not settled anything. The debt is still there. The fees are still running, and the car is still on the drive. What you have bought yourself is the thing people in this situation almost never get, which is a few days to deal with it in writing from your own kitchen, instead of on your doorstep with a stranger watching you decide. Learn it now while nothing is happening at your door. Subscribe so you know the words before you need them. And please, if there is real money involved, take everything here to someone qualified. This has been general information about how the law works in England and Wales, not advice about your situation. For that, speak to a qualified solicitor.